Hello and welcome to the CWEA SYP webinar series. We're working to educate our SYP members and the broader CWEA community through this webinar series. So for this series, we're looking at MOU labor relations, negotiations, rules, roles, and responsibilities. It's aimed a little bit more at public sector employee negotiation basics. So we'll have two public sector labor relations HR experts here to present the basics of public sector MOUs and labor relations. Our learning objectives are to understand the legal framework governing public sector negotiations within a unionized environment, learn about the various phases within the contract negotiations process, and gain knowledge about the responsibilities from all parties, management, employees, and union representatives. This webinar will be recorded. Our presenters are Cheryl Rhodes-Alexander, a human resources professional with an extensive diversified career in the human resources field. Since 2006, Ms. Rhodes-Alexander has worked for the Delta Diablo as their human resources and risk manager. Sonia Stankina is a public sector human resources professional. Ms. Stankina began her career with the City of Hayward in 1999 and now works as HR and risk manager at Contra Costa Water District.
All right, thank you, Simon, for that presentation. Cheryl, you want to start us off?
Yes, good afternoon, everyone. Thank you for allowing us to spend your lunchtime sharing a little bit of information about public sector labor relations. This presentation is intended to last approximately 45 minutes so that we can take a full 15 minutes at the end to address any questions that you may have. Because of the limited time, this is a 30,000-foot overview of public sector labor relations. To be thorough, this would need to be a 6 to 8 hour workshop. So if we do not address the main topic or question you expect it to be addressed, please use the time at the end to bring forth what is on your mind. Also, we are available after this webinar for phone calls or email to answer additional questions you may have. Our contact information is provided in the last slide. We will be touching on a number of areas and providing additional information, so we encourage you to take notes. This webinar is not a substitute for legal advice. Please consult with your agency's legal counsel and/or union officials for specifics relevant to your agency and practices. Also, please refer to your agency MOU, personnel rules, or other applicable governing documents that are applicable to your agency. And with that, we'll jump into a poll question. So they will open up the poll. If you can submit your answer, click on what you believe the right answer is to the question. The National Labor Relations Act, administered by the National Labor Relations Board, or NLRB, applies to all employees, private and public sector government. Is that true or false? And we'll give you a few minutes to provide your response. Okay, and so we should see the response in just a few minutes. So 82% of you said the answer is true and 18% false, and the 18% were correct. It is false. The NLRB applies to private sector. We're going to talk about those rules and those acts and statutes that apply to public sector. So now we'll jump into the basics of public sector labor relations. So here's the purview. Ultimately, public sector labor relations is accountable for as fiduciaries for agency constituents, taxpayers, and ratepayers. We maintain labor relationships, and including managing conflict that may occur. Negotiate collective bargaining agreements, also known as collective bargaining agreements, memorandums of understanding, or contracts, labor contracts. We interpret and enforce MOU provisions, advise management and members regarding MOUs and labor law, and implement regulatory decisions, new laws, case court rulings, and arbitration awards as it relates to the public sector. There are a number of other statutes that govern public sector labor relations. This webinar will focus on Myers-Milius-Brown Act, or MMBA, which Sonia Stankina will cover later in this webinar.
Okay,
Sonia?
So, all right, let's talk about legal framework. So on the next slide, we have another poll question for you. And the question is, the scope of bargaining includes which of the following? A, wages, B, staffing levels, C, implementation of protected leave, or D, all of the above. Please go ahead and cast your vote. And looks like most of the votes are in. We'll get the results here in just a moment. Okay, wow, we've got quite a split. Nobody said B or C alone. We had 45% say A, wages, and 55% select D, all of the above. And this one was a little bit of a trick question, so if you did not get it correct, don't feel too bad. The correct answer is A, wages. Staffing levels and implementation of protected leave are what are called management rights. And a little bit later, Cheryl will elaborate on what that term means. But in essence, these are decisions that the agency management staff has the right to make. Now, the tricky part is that while staffing levels and implementation of protected leave, while those are management right decisions, unions have the right to bargain over the impacts of those decisions. So, for example, if the agency made a management decision to reduce staffing in one work unit, the union has the right to meet and confer over, well, who is going to do that work from those employees who are laid off. Does that mean that our remaining members are going to have to do all of this extra work? And if so, how are you going to compensate them? Is this going to turn into overtime? What is the expectation? So again, staffing levels and implementation of protected leave are management rights, so the scope of bargaining does not state that they have to be negotiated. The decision doesn't have to be negotiated, but the impacts do have to be negotiated if the union wants to discuss impacts. And we're going to get into that in a little bit more depth in just a couple of more slides. So, looking at the legal framework, regulatory laws and agencies. As Cheryl said, there are a lot of different laws that regulate public sector environment, depending upon what type of agency you work for. The focus of this session is to focus on the Myers-Milius-Brown Act. This is not to be confused with the Ralph M. Brown Act, which was enacted in 1953, and that regulates provisions related to the public's right to attend and participate in meetings of local legislative bodies. So that's the
Sonia,
Brown
can
Act.
Sonia, can I interrupt really quick? It looks like we're having some audio issues, getting some signals saying that the audio is not coming through clear.
Okay. I'm not sure what to do here. Is this any different? Is this any better?
Are we still having audio issues? It sounds like most of them saying they can hear fine. Is that better?
Can everybody hear okay? I can hear fine, yes, yes. My audio is very good. Okay.
Okay.
All right. Well, we'll go ahead and continue. So again, the Myers-Milius-Brown Act is not to be confused with the Ralph M. Brown Act, because many of us have heard that comment of or have heard the phrase the Brown Act, but that pertains to our governing board meetings. So the Myers-Milius-Brown Act was established the collective bargaining for local governments, including cities, counties, and special districts, such as many of our water agencies, but the MMBA does not include transit authorities. They have their own regulatory agency, their own act. The MMBA was established in 1968, and the details are provided for in Government Code Sections 3500. Interestingly, there was another significant event that happened in 1968 on April 4th in Memphis, Tennessee. I'm sure many of your light bulbs are going off in your head. Dr. Martin Luther King Jr. traveled to Memphis in support of striking African American city sanitation workers to protest unequal wages and working conditions. For them, there were no city-issued uniforms, no restrooms, no recognized union, and no grievance procedure for the numerous occasions in which they were underpaid. And so, yes, you guessed it, tragically, on April 4th, 1968, that was the date that Dr. Martin Luther King Jr. was assassinated. And he was there on a civil rights mission for African American laborers. So let's talk about PERB, the California Public Employment. Let's go back one. There we go. The California Public Employment Relations Board. Since 2001, PERB has had jurisdiction over the agencies and employees covered by the MMBA. There are a few exceptions: police officers, management employees, and the City and County of Los Angeles. PERB's responsibilities include the following. They administer the labor statutes, again for the MMBA, oversee collective bargaining, ensure consistent implementation and application, adjudicate disputes regarding the statutes. They maintain a list of arbitrators and provide mediation services. So PERB receives complaints of what is called unfair labor practices. You'll hear also referred as unfair labor charges or ULPs. This is when labor or management alleges that the other party has violated the MMBA. For example, if the union believes the agency interfered with their organizing rights or discriminated against one of their members for union activity, they would file a ULP, unfair labor practice, charge with PERB. Or, let's say if either party alleged that the other party engaged in bad faith bargaining, they would file a ULP with PERB. So the note at the bottom of this slide, referring to mediation, fact-finding, and arbitration, all three of those involve a third neutral party to assist in resolving the dispute. Under mediation, if the parties cannot reach agreement, then mediation can be requested by either party and is not binding. In fact-finding, it's the union who compels this several-month-long process. And this advisory panel of three, which includes one representative from each party, one from management, one from the union, and then a neutral third party, this advisory panel has a little bit more authority than a mediator, but the panel decision is also not binding. And then finally, arbitration is binding. And I want to clarify, some of our MOUs or labor contracts have a mandatory arbitration clause as it relates to, or when I say mandatory, what I mean is there's a provision in the MOUs that if union wants to grieve something to arbitration, it's mandatory. You have to go to arbitration to resolve a grievance. But few of our contracts have mandatory arbitration clauses as it relates to bargaining labor contracts. So two different uses of arbitration. And it's the state of California who maintains a list of qualified mediators and arbitrators through the California State Mediation and Conciliation Services. And I'm going to say that again for those of you who are taking notes. It's the California State Mediation and Conciliation Services. You can Google them and get to their website and learn a little bit more about them. So moving on to the next slide. Subjects of bargaining overview. There are three different areas: mandatory, outside of the scope, and then it varies. And sometimes it is not clear whether something is within or outside of the scope of bargaining. There are scores of itemized actions in which each of these categories can fall, and there's still disputes among the seasoned professionals to this day. So in these cases, the agency representative would confer with their labor counsel and get a legal opinion, because there can be significant consequences to the agency when management imposes new provisions that are really inside of the scope of bargaining without bargaining with the union. The ones that are easy, those that are clear and certainly within the scope of bargaining, involve things like employee compensation, anything having to do with wages or pay, work hours and schedules, and most benefits. For purposes of this webinar, we are focusing on the labor relations in the area of bargaining contracts, but within the context of the legal framework, there's some other legal rights of employees that you should know about. And they are Weingarten rights. That would be another area that you might want to make a note of. It's called the Weingarten rights. This includes when an employee is in a meeting with a reasonable expectation that the meeting involves or could likely involve discussion that could lead to disciplinary action against the employee. This is most commonly in a situation where the employee has been accused of misconduct and they are in the administrative investigatory interview. They are entitled to union representation. Also, when an employee is in a meeting related to the interactive process in an effort to reasonably accommodate the employee's qualified disability, and when an employee grieves an MOU interpretation or application. In all of these situations, the employee has a legal right to union representation. So that pretty much sums up as Cheryl adequately put it, the 30,000-foot overview of the legal framework within labor relations on a bargaining side as well as employee representation. So let's move on to the next slide.
Okay. So we're going to quickly talk about rights and responsibilities. And there are three different groups that this applies to. So we have the management rights, which we'll briefly cover. So the management of an agency has the right to determine the standards and level of service and the means and method of operating to carry out the agency work. So how the agency goes about providing the services that it provides, that falls under management rights. That also takes, if you break that down a little bit further, that looks at the organizational structure. How many positions do they need to staff in order to complete the work that they need to do? In terms of budgetary and financial decisions, how are they going to fund the positions or the work that needs to be done through the agency? Those are management rights. Staffing, again, we talked about that a little bit in terms of organizational structure, but a little more specific to that is how we go about hiring, promoting, demoting, transferring, assigning, or retaining employees, and then creating or abolishing a job classification. Now, Sonia talked about a little earlier about certain things that fall under the scope of bargaining. And in terms of staffing, while that is a management right, depending on how your MOUs and your agency employer, your rules are, you may need to bargain with the bargaining groups and meet and confer to talk about the impact of these hiring decisions or the job classification process. So there could be a situation where while it is a management right, there still may be an obligation to meet and talk with the union about the impact of those decisions that the management has a right to make. And then also on employee discipline. While the agency has the management right to discipline employees if they violate a policy or procedure or some rule, you still need to possibly engage with the union to discuss the impact of that. You also have to talk about the employee rights, and we'll get into that on the subsequent slides. In one particular situation, you may want to, if you have two employees that have the same infraction, you want to make sure that the type of disciplinary action that is being proposed and that ultimately would be implemented is going to be consistent. If it is not consistent for the same type of infraction, there's a possibility that the union could argue that they want to grieve that because you're treating the same infraction differently. And so those are some things you want to be mindful of. And so just understanding that in terms of management rights. On the other hand, management has a responsibility to bargain in good faith on items that fall within the scope of bargaining and also to comply with terms of the negotiated agreement. So once the MOUs or the collective bargaining agreements or contracts have been ratified and signed by all parties, the management or the agency needs to make sure that they comply with those the terms that are specified in the agreements, and then refrain from interfering with or retaliating against employee for engaging in union activities. And we'll talk a little bit more about that as it relates to employee and union rights. So we'll move to the next one. So in terms of union rights, again, this is the bargaining group, the organized group that is representing the collective or mutual interest of its members. So they have the right to negotiate as the exclusive representative on behalf of members. They have the right to organize employees for the purpose of representation and to visit the workplace to examine working conditions or for the purpose of investigating employee grievances. They do not have the right to just kind of mill around just for the sake of milling around here. There has to be a specific purpose while they're here if there are concerns, again, about the working conditions or if there is a grievance and they need to meet with their members and represent them, they have the right to do that. In terms of responsibilities, bargain in good faith on items that fall within the scope of bargaining. And again, this is the same for management. So there's that mutual responsibility to bargain in good faith. Similarly, they have a responsibility to comply with the terms of the negotiated agreements and refrain from coercing employees to participate in union activity. And then they also have a responsibility to represent all employees fairly. Now, looking at the employee, specifically the individual right. As an employee, you have the right to join a union or refuse to join a union. Be free from intimidation from management or the union for participating in union activities or refusing to participate in union activities. Employees have the right to have union representation present during disciplinary proceedings, as Sonia spoke about earlier, and then have union assistance in filing for grievances. Employees' responsibilities are to perform work as directed by management unless ordered to do something that is unlawful or unsafe. And then also employees have a responsibility to observe the provisions of the negotiated agreement. And I want to make it a reference point to the Janus decision and its impact on union rights and responsibilities. On June 27, 2018, the United States Supreme Court issued a majority decision in the Janus versus AFSCME Council 31, whereby public employees have the right to opt out of paying agency fees or union dues. The agencies can no longer collect dues without an employee's affirmative consent. Also on June 27, 2018, then California Governor Jerry Brown signed Senate Bill 866, known as SB 866, into law. This Senate bill prohibits employers from deterring or discouraging union membership, limiting disclosure of new employee orientation. So it's not something that's widely broadcast. It's so that the unions have an opportunity to speak to new employees privately about union activities or other things relevant to union membership. In addition, Senate Bill 866 requires employees who wish to change their union membership to work through the employee organization regarding their membership. So instead of an employee coming to human resources or personnel saying, I want to change my membership status or make some change, they have to go through the employee organization. In addition, employers are required to rely upon the union to notify them of an employee's authorization to start or stop their union, the collection of union dues. Also, there is a obligation on both parts, primarily for the employer, though, to meet and confer on any mass communication to union members. If you want more information about the Janus decision or Senate Bill 866, you can do a Google search and there's a wealth of information available to talk about those decisions specifically and how they apply to and impact labor relations in the public sector and union with employees. Okay, so now Sonia's going to talk about preparing for negotiations.
Yeah, we're going to learn about the various phases within the contract negotiations process. So you're going to hear the term at the bargaining table. So on that theme, we know that a great meal begins with preparation. You've got to have the right ingredients, you've got to have the right location, ambiance, presentation, you've got to have the right people there too. And for some of you out there, including myself, you got to have the right bottle of wine. So you got to set the table just right. So moving on to our first poll question, or actually I think this is our last poll question, but our first of this section. So labor negotiations can be mutually successful if both parties, A, are willing to negotiate in good faith bargaining, B, are willing to work towards a mutually satisfactory agreement, and C, are willing to give and take, seeking a compromise, and D, all of the above. So I expect that we're going to have a 100% aggregate response on this. I'm sure everybody will get this one correct.
So cast your ballots and your votes now.
Yes, please. And it looks like they are all done, and it is D, all of the above. Both parties have to negotiate in good faith. You do have a goal of reaching a mutually satisfactory agreement, and just like any relationship, you have to be willing to give and take and to compromise. So looking at the negotiation phases overview. There's really three phases. There's the pre, there's the being actually at the bargaining table, and then there's the post. So pre-negotiation preparation, negotiation sessions at the proverbial bargaining table, and then post-negotiations to ratify, adopt, and implement successor MOUs. And so the next slide does identify those indicators of a successful negotiations. Both parties will interpret at the end of the process that it was worthwhile and productive. They believe that their specific needs were heard and understood. Importantly, that their self-respect is intact and that both parties achieved their major objectives, though perhaps not to the measure desired, but that's to be expected in any relationship, and that's really what this is. The labor relations environment, it is a relationship. And so moving on to the next slide, pre-negotiations, preparation. There are a number of things that need to be done before you sit down at the bargaining table. Most of your work really is done in advance of that first meeting. Agencies typically prepare 6 months to a year in advance of sitting down with each party. And so, of course, we're going to review the agency mission and goals. Included in that would be to research problems with existing labor agreements. Maybe there's confusing sections of the MOU that make it so that it's difficult to consistently interpret and apply, and so those things need to be flagged to address during the negotiations. Maybe there's something in the MOU that the agency hates and just it wants to revise that section, and the union on the other side as well. So part of that first bullet point with reviewing agency mission and goals from the agency's perspective is doing a lot of research into what it is that we would like to change. Under researching the union's interests, the union would take a look at recent grievance issues raised since the last contract term. I'm not going to read the whole slide to you. I'm just going to touch on a few different areas. Under developing the resource bank of information, both sides should do salary and benefits surveys of local agencies within their competitive labor market to identify what different classifications pay. Compare benefits with local agencies. If your agency has a high turnover and people keep going to East Bay Mud or San Francisco SFPUC, okay, well, let's find out why. What's going on? Where do you as an agency need to fortify your pay or benefits package so that you can attract and retain top quality candidates? Also, in the bank of information, you as the agency rep would want to research pattern of settlements. What are some of the other agencies doing in terms of contract negotiation settlements? What is CPI? What are some benefits trends and changes in law? Cheryl did an excellent job talking about the Janus decision, Supreme Court decision. It has had a major impact, and it did necessitate immediate bargaining with both of our unions here because there were provisions in the MOU that were legally invalidated as a result of that Supreme Court ruling. When you are identifying your negotiating team, you want to include staff, operational management staff, to assist in helping to evaluate the proposals. As one person isn't necessarily, if you're the HR rep, you're not necessarily going to understand all of the operational impacts. So you need somebody in there that can help with that, as well as a finance person. Under preliminary strategy, you want to focus on the total package. Some of it is going to be economic. Some of it is going to just be MOU cleanup. You also want to schedule a closed session with your governing body in advance before you sit down and formulate your strategy so that you understand what your authority is from the governing board. When I say authority, that means how much do you have to work with in a percentage of the bargaining unit's total annual payroll cost. You also want to identify the employee members of the union's negotiating team and arrange for release time for these individuals. If the union wants 5 people and they are all coming from one work unit, operationally, you may not be able to sustain operations with that, so you need to have that discussion in advance before that first meeting. And that pretty much covers it on that side. So negotiations session at the bargaining table. So the initial session, you're going to do introductions. Depend upon the size of your organization, and as Cheryl, again, appropriately said, your MOU or personnel rules may identify how many people are allowed to be on each side of the bargaining team. But you're going to want to go through that process and do introductions. I'll tell a quick story. At one of my former agencies, the very first session that we went in to meet with the union, they had separated our tables, so there was about a 2-foot gap between our table and their table. Previously, the tables were pushed together, but when we left the room and came back, they put a big gap, and that spoke a lot about where they were at philosophically in that first initial meeting. You also want to talk about ground rules. Ground rules include items of agreement such as confidentiality, media statements, employee stewards are released from work without loss of compensation, but they're not entitled to overtime or mileage reimbursement, and what is the deadline for submission of all new proposals. And there's a whole bunch of other ground rules that are discussed typically in that first session. Some parties will want the ground rules just verbalized. Others may want them in writing with signatures from the chief spokesperson from each side. But it should also include logistics such as where will the meetings be held, what times, how many times per week, what about parking, how long in advance of the contract expiration do we need to reach an overall tentative agreement without having to do retroactive pay adjustments, and a lot more. But most importantly, who is going to bring the bagels and the donuts at each session? You may laugh, but that is really one of the important things on many lists of ground rules. Negotiation sessions are typically not audio recorded for many reasons. Foremost, it can promote posturing and inhibit free speech or the exchange of ideas when parties know that a verbatim record of every single word that they would say would be captured for all eternity. When presenting initial proposals, each side has to be careful not to have too many. During your preparation phase, you will have identified your top 3 to 5. There's a story from our labor council who he went into negotiations and the union presented a proposal with 100 separate items. And he said, I'm not even looking at this until you can get this down to, maybe 2 dozen. So you want to go in with a reasonable number of opening proposals. On this side, one of the key phrases is to focus on the interests. Look for ways to solve the problems in a manner that both parties can accept. This is a collaborative process where respect and creativity is integral to a successful outcome. And so moving on to the post-negotiations slide. These are really the steps of what happens after you reach what's called a tentative agreement. There's union ratification, which is a membership vote, governing board approval or adoption. That is also referred to as ratification. Successor MOU is created. Policies may need to be revised. There are informational sessions, training that may need to be held for all employee stakeholders or only supervisors. or only managers, whoever the changes affect, it's helpful to meet and make sure that those changes are communicated. And then prepare a checklist of items to address at the next negotiations, because unfortunately, it is almost impossible. I'm not going to say completely impossible, but it's almost impossible to get every single thing that you want. And so you just make a priority list for next time if you didn't get what you wanted this time. So looking at the next slide, obviously things don't always go as planned. So Cheryl, take us away on the labor relations difficulties. Oh, Cheryl, if you're talking, we can't hear you.
Okay, can you hear me now?
Yes, we can hear you.
And I'm not the Verizon commercial. Okay, so Sonia painted a nice picture of everything that can go well, but there are times where things don't go well just because we're human. So there are times during labor relations and labor negotiations where you may run into some challenges, and a couple of those things are listed here on the slides. One is impasse, where basically you're at a standstill. You're not able to move forward. We've presented our side, the union has presented their side, and we just cannot make any forward progress. And so now we have to go through a whole nother process. There is this unilateral implementation, but before that, you have an impasse. Now you have to go through fact-finding, and that means you have to spend some time through mediation and through legal processes. By law, we're required to, if you hit impasse, you have to go through fact-finding. And you have to really just kind of dig in and look at all of the pieces of how can we resolve the impasse? And you have to work together with, a mutual party to help you get to that point where you can then hopefully resolve that impasse and move forward in negotiations. And then sometimes if you're not, then you have to look at what is unilateral implementation. And it is after you, for the most part, have done and said all that you can, you can impose basically, here's our last and best offer, and we can impose that, but you still, once you do that, it's only for a finite period of time. Then you have to literally come back and go back through fact-finding and other processes. And Sonia, chime in if I'm missing anything about that. But I'm just trying to keep it at a high level, being mindful of the time. So, and then other difficulties could come up where you have grievances there, and that deals with the interpretation or misinterpretation of a language in the MOU or how something is implemented. And so you can have grievances, and there could be a process, whatever your MOU or your personnel rules say, how you respond and how grievances are handled. That is going to be specific to your particular agency. Unfair labor practice complaints, that would be filed with PERB, the Public Employees Relations Board. And that can go both ways, not just against the agency, but it could also be an unfair labor practice charge could be filed against a union too if there are concerns that they are not bargaining in good faith. And then other difficulties could be strikes, sick outs, slowdowns, labor demonstrations. All of those different things could be classified as labor relations difficulties or challenges that could happen during the course of negotiations or during the life of an MOU. And so, again, we were only giving you a 30,000-foot level view of what labor relations looks like in the public sector. There are a ton of resources to dig deeper. The list that we have provided here is not all-inclusive, but some of the resources that we rely on, other agencies rely on, and I'm sure some unions rely on too, are the California Public Employment Labor Relations Association, CalPELRA, the Association for California Governmental Human Resources Professionals, CalGov, HR, the International Public Management Association for Human Resources, IPMA, HR, and then through the University of California at Berkeley, they do have a department called the California Public Employees Relation Institute for Research on Labor and Employment, and they put out pocket guides, and they have a gazillion of them on all different topics related specifically to all aspects of labor relations, and they are an excellent resource. And then there's a book that was put out by the late Madge Blakely of Calpella called You're the Boss, and it deals with workplace labor relations guide for public sector managers and supervisors. And there are just a host of other resources that you can Google to find out more and more information about public sector labor relations. And so with that, Sonia and I will open up for any questions that any of the participants would have.
And we see one question already. I'm going to go ahead and read it aloud. If the employee's representative, called shop steward, does not represent the employees properly and clearly put their own personal benefit over the group's benefit, how should the employees proceed to address the issue? And then in parentheses, the issue was already communicated with the union's business rep and they were not responsive, saying that they do not have the plan to change the shop stewards. Cheryl, do you want to take this one or do you want me to take it? What do you think?
I'll start and then maybe you can chime in.
Okay.
So in that kind of a situation where the employee feels that their shop steward is not properly representing them and their issue going forward, we as the agency, the management, cannot interfere in that. That actually has to go back to the business agent, to the employee organization, and you work through it with that aspect because, again, under Senate Bill 866, we cannot deter or interfere or discourage union activity or anything like that. So as management, we want to stay clear of that, and we would have to refer the employee back to their union to seek some type of resolution.
Yep, and I have nothing further to add. I can just emphasize what you said. The relationship between our employee and us is one thing, but when the employee is a member of the union, they have to work directly with the union if they have any issues with the union whatsoever. So that's spot on. Okay, we have another question. I'm going to go ahead.
So I'll let you. I'll read it, and you can answer the second question.
Okay.
So we said earlier that management is responsible for staffing decisions. Does that give them permission to unilaterally hire a temporary employee for a position covered by an MOU?
Great question. So one of the favorite responses of public sector HR professionals is it depends. And it depends, you know, again, we hate to keep beating the dead horse, but it's true. You really have to look at what the existing MOU says. You have to look at other side letter agreements, any personnel rules that you have. So you have to check with your own unique agency provisions. And so I'll answer it with our agency because there's just not enough there to really address the breadth of different situations. In our agency, we do have 2 unions, and each one have different provisions under our clerical and our maintenance union MOU. We do have a provision for temporary employees. So the answer is we could hire unilaterally a temporary employee within the parameters that the employee does not exceed, say, 6 months in duration. And that it's project work, or maybe 1,000 hours in a fiscal year or a calendar year. So it really depends upon what the documents say. If they're silent, then you have a little bit better chance of being able to move forward with unilaterally hiring.
Very good. All right, and then we have another question. What are some alternatives to proposal-based bargaining? We have done interest-based in the past. Any pros and cons?
Do you want to take that one, Cheryl? Or? Oh, okay. So my response is I have not done interest-based bargaining. Each agency that I've worked at, we've only done position-based bargaining. I have not heard good things about interest-based bargaining, and I've heard that it usually evolves back to position-based bargaining anyway. So I'm sorry, just I don't have a response on interest-based.
And I don't really have a response because our agency has a lengthy MOU in place and has been for the majority or actually all of my career. So I can't respond to that. I don't have a pro or con.
Mm-hmm. Yeah, but certainly if whoever asked the question, Mr. Welch, we would be happy to talk
offline.
Mm-hmm. Yeah, and get some answer, get the answer to your question, because we have plenty of colleagues. That's one of the beautiful things about public sector HR. We share resources, and we can reach out to any of our colleagues who have done interest-based bargaining, and we can share their response with you after the webinar. So the next question, how long can an employee be on modified duty if hurt outside of work? Okay, that's a tough one.
And that's something that's beyond what this webinar speaks to. I would refer you to your risk manager or your safety manager, or if you don't have either of those, I would talk to, depending on if your agency is with the California Sanitation Risk Management Authority, CSRMA, you may want to consult with them or legal counsel as to how you would handle that type of a situation, because when an employee is on modified duty, again, you're getting into leaves of absence. You're also dealing with the interactive process, reasonable accommodation, ADA. So there's a lot of different things that come into play. So it wouldn't be appropriate for us to give you a response to that. You're going to need to consult with a variety of resources in order to give you the best answer for your specific agency in that specific situation.
Well said, Cheryl. Yeah. Okay.
And can you explain the meet and confer for mass communication? So under, as I mentioned in the Janus decision, they require, if there's going to be any communication to employees with respect to, and I'm just going to read a summary of, so there has to be procedures that are mutually, where you meet and confer when the employer wants to communicate or disseminate information to employees or applicants concerning public employees' right to join or support an employee organization or to refrain from joining or supporting an organization. So an employer just can't send out a blanket email to employees. They have to meet and confer with the bargaining group to agree on what that communication piece is going to look like, the content of that. And so that's what meeting and conferring regarding mass communication, that's what it's referring to.
Yes, and I would only add one item, and that is if they cannot come to an agreement, then the agency can still go ahead with presenting the mass communication piece, but they must attach or include a piece from the union that is similar in length. So that way both documents would go out together at the same time. And I hope that answered Christina's question. We still have about 5 minutes remaining. And if there are any other questions, you guys have good questions. And I'll wait just another moment in case somebody's typing something right now.
There was one question in the chat about how important is it to sign off on a new MOU? Can the City Council enforce a successor MOU?
Okay, so can you repeat the question?
sorry, how important is it to sign off on a new MOU? Can the City Council enforce a successor MOU?
Okay, so and Sonia, I guess we'll have to tag team on this together. So the question is, when you say how important is it to sign off on the MOU, are they referring to the bargaining unit, or who are they referring to?
Yeah, we don't have enough information on that.
Yeah, I'm not really sure we can adequately answer that question without knowing who are they referring to. Is it the bargaining unit, or are they referring to the agency?
So typically the process is after the tentative agreements are signed during negotiations, and as we mentioned on that post-negotiations slide, it's voted, ratified by the union membership, the board approves and adopts it, and then a successor MOU is drafted, and that's done typically between the HR representative and the business agent representing the union, and they go back and forth and get to the point where everybody agrees on how to incorporate the new provisions of the tentative agreement, which has now been adopted by the board or the City Council, and how they want it reflected in the MOU. And then they have a signature page, and it's signed by representatives from both parties. And so that's why it's a little, we're not sure of the question. But it is important that both parties sign the successor MOU. Okay, another question. If you merely have an employee organization, not a union, what rules apply? So an employee organization sometimes will have an actual resolution. They will have a document that identifies the provisions of their benefits, of grievance procedures, and so I would refer you to that document. If they are not represented by a union, then many of what we have discussed does not apply, but some does. It's just too broad of a question. We'd have to have a little bit more what bargaining rules apply. I'm not understanding. Cheryl,
so
you take that?
I'm again with Sonia, I'm not exactly sure of the question, but most likely in terms of bargaining, you're referring to statutes, and that most likely, if you're in a special district, most likely it's going to be the MMBA. But there could be other statutes that apply. So again, it's not, I can't give you a definitive, it's just MMBA, but it might be the MMBA, depending on how your organization is structured. If you're a higher ed, there's some different statutes that apply. So it really depends.
Okay, and we see, does Janice apply to a non-union employee
William,
association?
We have a question from William. If we can jump to that first, William Lohman. We are undergoing a reorganization presently. While the employer is being proactive so far, the understanding is that the employer is free to impose reorganization as it sees fit, but we can still address the impact by the reorganization, it seems. Have I understood that correctly?
Yes. Yes. Good. We're pleased that apparently the webinar was clear enough. Yes.
Yes. So again, under management rights, the organization has the right to determine the structure of the organization, but it may be obligated to discuss and meet and confer about the impact of that structure. And so, correct. Yes, you did understand correctly. Mm-hmm. So now going back to the other question, does Janus apply to a non-union employee association?
Yes. So Janus, the Janus decision basically made it unlawful for public sector employees to be forced to pay union dues or an alternative association or union fee. And so no longer can unions or non-associations compel employees to pay dues or fees. So that's correct. It does apply to non-association. Let's see. Please define MMBA. That's the Myers-Milius-Brown Act and Section 3500 of the California Government Code. What happens if your MOU expires while you are in the process of negotiating a new one? I'll let you go ahead and answer that, Cheryl.
Oh, I don't know, because I haven't had that situation.
So it continues. The current MOU continues until all of the provisions stay the same until you negotiate a successor MOU. And we are at 1 o'clock, and I just want to thank everybody for being very engaged and actively submitting questions, challenging us. And again, we're serious. If you have any questions after the webinar, feel free to reach out to us. We're more than happy to continue to assist the CWEA. It's been a pleasure to help inform you on labor relations.
All right. Thank you all, and thank you for the wonderful questions. Great questions.
Thanks, Sonia and Cheryl. And this has been an SYP webinar on negotiations. Thank you all for listening in.